Canadian employers across all provinces and all sectors are struggling with labor shortages. Welcome to the show. Let's find out how you can hire foreign workers for your Canadian business, which is proposed to be one of the solutions to the existing labor shortages. Don't go far away.
Just a quick reminder before we start. Please know that whatever you hear in these live sessions or any content you see on social media by Savi law firm is general information only and not legal advice. While we may use certain real-life scenarios or legal cases for learning purposes, it is important to remember that this does not constitute a legal opinion. For personalized legal advice, please consult with your lawyer or hire a Canadian immigration lawyer. Now, let's get back to our show.
Welcome to the show. Every Wednesday at 10:30 a.m. Toronto time, we go live covering one specific subject related to business immigration. Make sure you follow us on many social media channels that we put the content to. Today's topic is how to hire foreign workers in 2024. We will be focusing on LMIA-based and LMIA-exempt work permits for foreign workers. It will be a general overview of the situation and the steps you need to take and stay compliant. And of course, we will get to your questions during this live show after my brief presentation. So in part one, I want to give you a very high level steps and hiring factors. What is considered by the immigration office and ESDC office in your hiring process. On a very high level, the process looks like this. Step number one is identify the right candidate for the job. Understand if your company needs LMIA as a second step. Third step, if your company needs an LMIA, apply for LMIA. Workers and then submits his or her application for work permit. And then once you bring the foreign worker, your obligation to stay compliant continues as long as you hire that foreign worker as a foreign worker. Okay, this is a very high level process. Let's go step by step. Step number one is to identify the right candidate. Officers must be satisfied under the regulations, immigration regulations, in basically the work permits. When officers are considering issuing work permit, the legislation says the following: an officer shall not issue a work permit to a foreign national if there are reasonable grounds to believe that the foreign national is unable to perform the work sought. So there is a very vague and very generic language of the legislation, and based on that, the officers must be satisfied that the foreign national can perform the work that he or she is applying for. Three sources that the officers will check to conduct their assessment. First is a NOC code and the employment requirements for the position. We will delve into that in the next slide. Employer's evaluation and LMIA if provided, so if required. So tips for this step only. Step one is before sending a job offer to a candidate who is a foreign national, make sure to review the employment requirements under the NOC, the related NOC code. And also pay attention to your candidate's language skills. Because yes, I understand in certain professions maybe language is less important, but you need to make sure that they have the right level of language skills. Most cases get refused due to insufficiency of language skills. So make sure that because you spend energy, time, and financial resources, make sure you find the right candidate. Let's see an example here. For example, if you are hiring, assume that you are hiring a restaurant manager under NOC code 630 employment requirements. You need to read them very carefully because they are there for a reason. They're not just generic statements. Especially pay attention to the highlighted section where your manager should be able to resolve customer complaints and ensure health and safety relations are followed, and so forth. Negotiate arrangements with clients and with suppliers. As you can see, the language aspect is very key here, right? your manager not only knows how to manage people, but they need to verbally communicate, and in writing they need to be communicating in the language of this country, either English or French, depending on the location of that job. So tip here is your candidate should have relevant education in the hospitality industry, of course, that's by default, and several years of experience in the food industry, as you can see in the underlined section of the requirements. Including a supervisory role, your candidate must be able to communicate in English or French to perform the listed duties, especially the ones that require communication skills. So many people say, I have enough English, I have enough French. What does enough mean? So there are strict language tests. For example, you may require your candidates to demonstrate objectively their language skills. They can say, oh, I've been learning English and speaking English for many, many years, but then the objective proof is usually the language test. That's one example of the importance of language, the job requirements under NOC code that is specific to your position. Step number two. Step number two, understand if you need LMIA. That's in a nutshell, very important strategic move. You need to understand whether you want to hire through LMIA or without LMIA. Of course, without LMIA is an easier and faster process. So, for example, if you employ these individuals listed here, you don't need LMIA, which makes your life as an employer easier. So you need to pay attention here. For example, specialized knowledge workers or managers from the parent company can be transferred without LMIA. Professionals and technicians in specific occupations from free trade agreement countries. And they are listed here: US, Mexico, Colombia, Peru, Chile, South Korea, EU countries, Panama, Japan, Australia, Brunei, and the UK, and Malaysia. So when you are selecting candidates, you need to make strategic moves, because LMIA it costs you money. It costs you in legal fees and so on. So when you find the right candidate, things will be easier for you financially and in terms of process. Some professionals for a short term, usually less than 90 days, don't need LMIA to come and fix something in your business. Television and film producers, and these are especially French-speaking workers outside of Quebec. Why it's there? Because Canada wants to promote francophone speakers outside of Quebec. So this is a very good target group for your hiring, for your positions. And of course, certain type of short-term professions or roles, especially young professionals. For example, in the list you can see young professionals from certain countries, from FTA countries, Andorra, Costa Rica, Hong Kong, Taiwan, and Ukraine, and so on and so forth. I will give you some examples of this in the next slide. So understand, if you don't need an LMIA and you can still be happy with the selection of candidates, I suggest go without LMIA, which makes your life easier, right? So hiring LMIA exempt workers, some scenarios of our clients that we helped to hire foreign workers. Let's see. For example, a construction company hired French-speaking construction workers from Haiti, that's a francophone country, through Francophone Mobility Program. So if the role doesn't really emphasize English language skills, but you're okay to hire French-speaking individuals from French-speaking countries, that could be Francophone Mobility Program, could be a good way to go. Another example, a Toronto-based professional consulting firm hired a management consultant from Chile, again, based on the Canada-Chile Free Trade Agreement. A restaurant in Canada hired a chef from Peru, again, based on Canada-Peru Free Trade Agreement. A hospitality company hired a customer service representative from Lithuania using the young professional stream under International Mobility Program. So, and so on and so forth. An IT company transferred some key employees from Iran to Canada, intra-company transfer without LMIA requirement. Step 3, if you now determine that, yes, I need LMIA, unfortunately, those exemptions don't apply in my situation and the chosen candidate that I've selected, then you need to apply for LMIA. LMIA stands for Labor Market Impact Assessment. Basically, ESDC, Employment and Social Development Canada, an office evaluates whether you hiring foreign worker has any negative impact on the Canadian labor market. So, Labor Market Impact Assessment is that exercise. So, LMIA process involves the following step: advertise the position, genuinely attempt to recruit Canadians, Canadian residents or Canadian citizens. LMIA application to, you submit LMIA application to ESDC office, interview with the ESDC office, and the decision is rendered by the office. There are different types, categories, and different requirements and steps may be involved. So high wage LMIAs, low wage LMIAs, agriculture stream, global talent stream, LMIA to support PR application, and so on. So advertisement requirements and wage requirements may be different for different streams. There are a lot of, the general rule is yes, you need LMIA, but there are many exceptions. Even within LMIA pathway, there are different categories under the advertisement might be different. So it gets confusing as you go deeper and deeper in the hiring process. So tips for this section for those who need LMIA, a general overview: advertising the position. Very important, that shows the genuine intent and attempt to hire local Canadians. So common reasons for LMIA refusals, don't forget, it's improper or insufficient advertisement. So basically government says you need to make sufficient steps to make your positions known, open positions known to the Canadians, so they have a fair chance to apply. Advertising at Job Bank is mandatory. That's a jobbank.gc.ca website maintained by government. It's vetted by government and so on. Make sure your ad is always active during the entire LMIA process, not just 30 days. Entire LMIA process, when it's completed, then you can remove the ad that you put on Job Bank. Ensure that you are offering a median wage for the position. Check the median wage also on the Job Bank website. There are a lot of trends and analysis based on your location and so forth. Try to advertise, in addition to Job Bank, try to advertise in 3 or 4 more sources, including one paid source, which is like Monster, Indeed, or LinkedIn websites. Specialized websites for specific occupations. For example, if you are hiring truck drivers, you need to go to that industry websites and then advertise there. And also one source for the underrepresented groups. For example, newcomers to Canada have their own places where they congregate, the websites where they visit for jobs and so on. That specific unrepresented groups have website, and you need to add your ad into that website too, just to give fair chance for everyone to apply. Most importantly, it's been a very big pain point in the hiring process. Do not tailor your advertisement to fit your candidate, okay? It should be general enough. Don't make it so specific to the candidate that you've chosen already, okay? It will be obvious and government will refuse. The goal is to allow as many Canadians as possible to apply for your position. You may be refused if your job advertisement discourages local applicants from applying. For example, asking for foreign language other than English and French. For foreign language skills is a classic mistake done by employers. The minimum duration for advertisement is 30 days for general websites and continuous recruitment for Job Bank. As I said, once your hiring process, the whole process is completed, then you can remove your advertisement. Further tips, with respect to attempting to recruit Canadians first. That's the whole logic and philosophy behind LMIA process. When creating your job posting on Job Bank website, select the default or the basic option. This option allows matching with job seekers from a wide variety of backgrounds as opposed to strict selection mode, where matches may be limited to fewer jobs, and ESDC will question how did you do, like even technicalities. Did you use the default mode, or did you use too strict selection filters, and so on. When seeking to fill a high wage position, that's very important. There are high wage position basically giving more money to the employee. You are required to invite all job seekers matched within the first 30 days of your job advertisement to apply for the position if they are rated 4 stars or more. So the matching algorithm basically on Job Bank gives you stars basically. So it gives stars to the candidates, and you need to invite those that are rated 4 stars or more. Try to interview at least 3-4 local candidates. Do your genuine and show your genuine intent to hire Canadians, and document all your recruitment efforts. Documentation is the key, and ESDC will ask for it. You will be asked by ESDC officer why you could not find a suitable candidate from within Canada. Why you have to bring a foreigner to Canada. Yes, the unemployment rate is around 5.7% at the moment, but depending on the positions, the candidates may be abundant within Canada. So ESDC officer will be asking you for that. LMIA application interview. So you will be interviewed by ESDC, and don't get too nervous about it. It's a standard procedure. Choose the proper knock code. LMIA application, you need to choose the proper knock code and include the documents that are listed in the form, including copies of all advertisements showing the duration and so on. For companies that have been active for less than 12 months, you need to or lower revenue, you must include an additional attestation letter from your lawyer or CPA saying that you have enough money. Although you are a young company, you have enough money to hire for that position and pay foreign workers' wages. LMIA interview by ESDC. Do not be intimidated. These are formal, these are procedural things, and informal, quite informal. They call you, and your lawyers can be there too. ESDC officer will ask you questions based on your LMIA application form. The main purpose of the interview is to verify about your company's active engagement in business, your company's needs for talent. Do you really need that foreign worker? And whether the recruitment efforts to hire locally were done properly. So it's basically a report. And then after that, they can give their own decision. If you've done things right, they will give a basically positive LMIA. At any given time, you may request the officer to send the responses in writing. Officers will send responses in writing. You can also ask your immigration lawyer, business immigration or corporate immigration lawyer, to attend the meeting with you to help you answer the questions. So it's not an interrogation, okay? It's a normal Q&A session basically to understand your needs for talent. Step 4, which is an important step, work permit application. Once you've done all this, once you've gone through all the hurdles of advertisement, LMIA, and so on, you need to support your foreign workers, in applying correctly. So that you don't, there's no technical mistake and then all your efforts are wasted. So how to support your foreign workers' work permit application? You need to provide your candidate with employment contract clearly outlining the role, duties, and job requirements. Tip here, ensure you don't include anything that is outside of the scope of the NOC requirements. Okay, go with the NOC. Read the NOC requirements and demands of NOC code that you are hiring under. Prove your candidate. It's not prove but provide here. Sorry about the typo. Provide your candidate with a reference letter clearly stating how the requirement was conducted and why you believe your candidate is a good fit for the position. Address problematic issues. For example, the candidate's modest language skills could be addressed by showing the limited need for language skills in that position and the accommodations you have at your workplace. If it's a remote area, accommodations should be covered too. These are problematic areas most of the time. Address them, don't hide them. Encourage your worker to include specific evidence about his or her ties to home country and abundant documents to show his or her ability to perform the work that you are hiring for. So what I'm trying to say in step 4 is that once you've done internal within Canada, all the processes, get an LMIA, do all the hurdles, now there's an external process which is at the embassy level, right? Embassy level, the visa officer, again, scrutinize the worker's application, saying that, are you able to do the job? Will you return to your home country after temporary work in Canada? And so on. So help your employee, the worker, to make a successful application at the embassy level. Okay, now you've brought your foreign worker to Canada. He or she is starting working and everything is going well. Now you need to stay compliant. Why? Let's discuss. How to stay compliant as an employer. Never, ever, I will emphasize it, never, ever, ever try to get all your expenses from your foreign worker. Remember, internally, you've done all the expenses. You've hired lawyers. You did LMIA. You paid for advertisement. There is an expense. So it's on your shoulders as an employer. You cannot recoup it one way or another, directly or indirectly, from the worker. Okay? So never ever charge your foreign worker for the expenses you've done. It's illegal. Directly or indirectly, through recruiters, some kind of fishy schemes of putting a recruiter in between you and the worker. No, it doesn't work like that. Don't charge money for your job offer or recoup LMIA costs, recruitment costs, training costs, or any other fees that may be interpreted as indirect charges. Okay, like orientation cost or whatever. Like employers may get too creative sometimes. They say, oh, I've made some so-and-so expense. How can I recoup? No, it's on you. You needed that foreign worker. You covered all the expenses and then bring him or her to Canada. You pay his or her salary in full, not with any deductions. Of course, tax deduction and other regular deductions are okay, but you don't recoup your costs of hiring him or her. Pay your employees the promised wages and comply with the terms of your LMIA or job offer. If LMIA is not required, LMIA or job offer fully. You need to comply with that. If your employee decides to quit or you want to terminate the employment of that foreign worker, you need to notify the IRCC, Immigration Canada, and ESDC about that termination. Follow proper termination protocol and document all efforts to support your candidate's compliance with the terms of their temporary stay. If there are any disagreement or arguments, use legal means to cover, to proceed. Provide your worker with information about his or her rights as a temporary foreign worker in Canada and document it. Remember, 50% of Canadian employers who hire foreign workers are audited for compliance, and you may be asked to pay a very big penalty, up to $100,000 if found abusing the rights of your foreign worker. That's very important. Why I am going into details? As you may feel, there are some tensions about immigration in Canada at the moment. Some people say immigration is good, some people say immigration is bad. And government is on high alert for any abuse of foreign worker rights. You need to stay compliant so that you can continue hiring foreign workers if your business needs more labor force. Okay? That's why the political environment is a bit very sensitive, and legally speaking, you have certain obligations. If you stay compliant, you will be treated as a trusted employer and be allowed to hire more and more and faster for your business. That way your business will be strong, have enough workforce, and be more prosperous overall. So staying compliant is very, very important. That's my conclusion. If you need guidance in hiring foreign workers, in business immigration, in corporate immigration, you need an honest, competent, and caring team on your side. Sobirov's law firm can help you with that. We have a detailed analysis and detailed guides on our website. Make sure you follow us